Are you assured that there are sufficient skills and capacity in the market to remediate at the new pace that you're looking for?
Thank you for that question. It's an area that we monitor extremely closely. Obviously, it starts with the ability to access fire assessors. Some of your previous witnesses were talking about the barriers that we've seen there before. Helen can speak to what we've done in Homes England, where we've created state capacity within the cladding safety scheme to ensure that people can get access to assessments quickly. That's currently underutilised. We've offered to extend that panel out to developers as well as a means of making sure that buildings get assessed very quickly. So we don't see any shortfall there at the moment, and we've got additional capacity that we can use. The vast bulk of the assessment process has been completed in the social housing sector based on their published data. Beyond that, we're working closely with the Construction Leadership Council to provide modular training on, for example, facade engineering and cladding and rain screen courses. The cladding safety scheme will be publishing pipeline data in future. Obviously, the best way to scale capacity will be for the private sector to invest in ensuring its own supply chain is sufficiently robust. We can help that by being more transparent about what is coming down the way, and we've signposted to other tools such as where the immigration list permits cladders, for instance, to be sponsored by employers. So we don't currently see a construction industry and capacity shortfall, but we monitor it carefully and we try to promote private sector investment in that supply chain where we can show that the money is available.
Sometimes what happens is that the exterior cladding problems are identified, the scaffold goes up, the exterior cladding is taken off, and then you find that there are other problems, for example, voids and so on, and then a frightful argument takes place as to who's going to fund that. And meanwhile, the poor residents are left not only with no exterior cladding, but that scaffolding, which can be up there for years. What more can we do about to smooth the process?
You mentioned other types of defects which made non-cladding related. We're working with the BSI to develop a similar risk-based standard to help give the sector more certainty about what work does need doing or doesn't need doing. Early on in this programme, there was a lot of ambiguity about that, for example, in relation to cladding, which meant the work was being done which didn't actually need to be done, and it was causing anxieties which were sort of not sufficiently founded, and the BSA should be introducing that standard this year. I think settling some of these questions as soon as we can, as early in the process, is really important. Helen can speak to what we've done to streamline that in the cladding safety scheme, but for example, our key performance indicator there has taken about 8 months off the process from a building coming to the point of application through to getting to a package of works, and we've managed to take the average time down that a building's on site by 2 or 3 months as well. Now, obviously, we always want that to go faster, but that's a significant incremental improvement on buildings which can otherwise take easily 18 months to move through. In terms of funding for those other defects, again, within the framework in which we operate, we will obviously pay for external wall defects and work that is kind of contingent to that work happening. Other types of defect, be they subsidence, fire stopping, compartmentation, owner-occupiers are of course protected from those costs, but freeholders may have to meet them. The Act provides routes to recover some of those costs. We obviously help with the assessment part about what work needs doing on cladding. The framework doesn't extend into looking at other types of issues.
That's the point, isn't it? There is this passing of the buck between freeholders and developers. You can have a situation where residents of high-rise or mid-rise are living in property that are unsafe at that moment, but there is no light at the end of the tunnel because nobody is taking responsibility for getting the work done.
So I might come to Ben in terms of how we're patrolling the developers, but it's just worth saying that we have we've committed to a dispute resolution process to make sure that...
Is that working in your view?
We're just in the process of setting up a formal dispute resolution process. A process already exists where developers and freeholders have signed a contract of works between them. That is a requirement of the developer contract. But before they get to that stage, as you say, there can be disputes over the scopes of the works. We want to provide a formal route by which the parties can reach an agreement. In advance of that, we have sought to arbitrate between parties. So, for example, we ourselves undertake an assessment on behalf that both parties accept will be the final assessment in order to broker a deal around the right scope of the works in order to allow for that works to go ahead. So it's not something we ignore in the meantime.
Those parties to engage in that process, doesn't it, and to accept the final view. The representation that I've had from residents is that it's not working, and that's why we have years and years of them sat in properties that are unsafe, where developers and freeholders are passing the buck. Is it your view also that the system we have at the moment is not allowing for a resolution between developers and freeholders? And I asked that question in light of pending legislation, and I would hope that would be rectified. But again, I underline the point that in the meantime, actually we have lots and lots of people who are on unsafe properties who are stuck between freeholders and developers who are not coming to an agreement.
It's certainly the case that parties can reach an impasse and are almost unwilling to unblock the impasse for various reasons, which might be no fault of either party, just they've come to different views. As I say, some of this is around where ultimately the department believes, or enforcement agencies believe, the truth lies to an extent. So if we or an enforcement agency undertake an assessment that we believe is to represent the correct scale of the works, and a freeholder, for example, refuses to accept it, I think we would want to consider an enforcement route for that freeholder to ensure that they accept that is the work that needs to be done in order to get that work done. Conversely, if it's the developer that don't accept that is the scope of the work that needs to be done, we have mechanisms within the contract ultimately allowing us to stop them being able to develop further properties in order to make them comply. So it's not that we don't have any routes at the moment, it's the process of getting both parties to the stage where there's no other route and we are basically apportioning.
I would suggest that's not being utilised. There are many examples of developers who are still being granted permission to build where they are responsible for remediation works that aren't being completed. The BSI that officials have already in part touched, I think there is some work underway to look at reviewing, is it the PAS standards? It is critical because people are being faced with a huge increase in their insurance. I wondered if you might comment on that process of reviewing those standards and what currently, in terms of government efforts or department efforts, are underway to discuss with insurance companies to try and reduce the burden of increasing insurance costs. I know the standards are one part of it, but there might be other things that we can do at the moment, and I wondered if you can give us some insight into that.
It's a very serious problem, and the department commissioned the FCA to look into the high-rise buildings market. It found some very significant increases in prices. We are bringing forward statutory changes to ensure that freeholders' fees and what they can charge in arranging insurance are also capped and controlled, because we found the FCA found some terrible practices in Passback there. But I think it's fair to say that problem is not resolved whilst dents have been made, and there is more that we can do, which Ben, you might want to speak to.
Of course, insurance companies, the way that they provide a price is all based on risk. And there will be some examples where insurance companies are going beyond that initial risk assessment and they're just trying to get as much money as they can. But it is also the case that there will, as long as there isn't a clear pathway for being able to deliver remediation works for properties, they will always assess the risk higher or higher compared to others for certain buildings. So that's why I'm asking about the BSI review, because do you anticipate that will address that?
We have got a risk-based standard. We think a risk-based standard is the right approach. A risk-based standard applies in terms of structural safety, ageing buildings, subsidence. This is not unique to fire safety. Obviously, we've asked the BSI to make sure that that framework is up to date. That was the first version of a risk-based external wall standard, so we want to make sure that it hits the test of time. That standard is designed to avoid another terrible catastrophe. We've obviously entrusted experts to give us guidance to ensure that's the case. They are re-reviewing that, but we don't accept that there is a correlation between overall fire risk in the built environment and the nature of insurance premiums, because it's simply not borne out in the number of fires there are and how many of them are catastrophic.
Just briefly on some of the other work we're doing. So the FCA report of a few years back now suggested that the industry put in place a risk pooling system in order to increase capacity in the market, leading to more competition, which would reduce rates by spreading risk. That has been in place for a little under a year now. We don't think it's had the impact that we would like to see in terms of reducing some of the most extreme premiums, and that's why, as part of the acceleration plan, we indicated that we want to understand what options we have to intervene in that market to see what we can do about premiums in the meantime before buildings are remediated. Your point is, will people perpetually end up in the state? The ABI have said premiums should reduce where risk is reduced, and obviously it's absolutely the case that the works that are going on these buildings reduces risk. So we absolutely expect the industry to hold to their word. It's something we need to keep a close eye on to make sure that those statements that they have made are held to.
I absolutely appreciate that there is commitment to do something about this, but after 8 years, after a huge tragedy, now we face, a situation where individuals are feeling utterly helpless, trapped in their own property, unable to sleep at night. So can I take the opportunity to urge officials to get on with it in conjunction with government, so that people can really get on with their lives and feel safe when they go to bed at night? Thank you, Chair.
Pass 9980, which is what you were referring to, is about proportionate approach to deciding what remediation work is needed and prioritising risk to life. It does not prioritise risk to the building, which is the primary concern of insurers, and we've had evidence from the ABI about this. I mean, can we bring in the insurers at an earlier stage when a building is about to be remediated, so that they are happy with the specification, and that if the building is remediated to that specification, there should be no inherent reason why, after it's been remediated, the insurance premium should be any higher for a building that's been remediated than any other building that doesn't need remediating? Surely that is the end state we need to get to on behalf of being fair to leaseholders.
I think I guess the issue with that is that then you essentially hand the decisions over an entire remediation project over to the insurers, who will want zero risk in any building ever. As Mr. Gibbon described, much like in any other system, an element of risk is allowed within a building context, because that is the proportionate approach. I guess the counterfactual of that is a lot more taxpayer money spent doing more work than is necessary to make a building safe, which obviously has its own issues. And so the balance that is struck in here and any other bit of health and safety or safety legislation or rules is around what is proportionate, what is the right amount of work to do, rather than remove and reduce every risk possible.
But is your point a bit like the mortgage issue, where kind of once a building has a programme of works underway, you get the insurer to assess it as if they had been completed?
Yes, exactly.
Yes. So I think this comes back, if I can, to your question around the standards and ensuring that insurers recognise what the standard does and doesn't do. It is obviously geared around catastrophic risk. So, for example, it is not a standard that would prevent smoke damage in a flat. but it would prevent damage to the core of the fabric of the building. I want to ensure that there was suitable evacuation as well. Part of this as well is about increasing the level of understanding about what the underlying levels of risk are. So sometimes that can happen on a building by building basis. What ministers have committed to is work with the industry as to whether there is further government intervention which might allow us to provide further support to the industry, because it is clear, back to your point about the residents of these buildings, it is not sustainable for 100% price rises on insurance premiums, something for which leaseholders are not responsible, for where there is money to fix the problem and where there is an expert agreed industry standard, and that position has to change.
Just on your last point, just briefly, so you are considering a government-backed insurance scheme if the premiums don't come down, as we have with flooding?
So what Minister set out in the acceleration plan was essentially dialogue with the industry, which builds on the FCA recommendation about whether there is more that government could do to intervene in the market overall in order to reduce premiums. But they've not reached a view about whether they definitively will intervene or not. But we've opened that conversation with the industry.
When the freehold's been bought by the leaseholders who own the individual flats in the building.
So on enfranchised buildings, ministers have committed to look at whether there are further policy steps they want to take to protect enfranchised leaseholders.
At this stage, they aren't protected.
Enfranchised building owners are the freeholder, so there's no relationship that we have interfered with through the Building Safety Act. So that's the framework as it currently stands.
What I said is correct. Two buildings, identical, social housing sector, one of them doesn't get funding, and the one next door, identical, and the private sector does.
It's certainly the case that there is no open access fund for remediation work in the social housing sector.
Has any assessment been done as to the total cost to the social housing sector, to councils and housing associations, of the work that would have been funded if those buildings had been in the private sector? Well,
so the colleagues at the NAO published an estimate of £3.8 billion worth of potential liabilities in the social housing sector.
3.8 billion. And has any calculation been done as to how many houses will not be built because that's money that's going to be spent on remediation, on building safety?
Well, it's certainly the case that social housing providers are having to balance a range of obligations. The Deputy Prime Minister has been very clear that she believes a landlord's responsibility to the safety of its tenants should be one of its primary priorities. It is, of course, the case that where a social housing provider is spending money on one type of activity, it's not spending money on another type of activity. That's one of the reasons why ministers want to take stock of the position overall in the sector ahead of a strategy in the spring.
So, right, it'd be helpful when taking stock is happening if we knew what that was currently based on. How many houses would that money have been spent on, or could it have been spent on, that's currently being used for remediation work for fire safety measures, that if those blocks had been in the private sector would have been funded by the Building Safety Fund?
So one could make a sort of crude estimate of how many social houses that might fund, but I think the context is a bit more complex than that, because a whole range of things that social housing providers are spending resources on, and a whole range of different contextual issues which have affected the viability and ability to invest of social housing providers, including the rent settlement and other issues.
So could we have that crude estimate then?
Well, I honestly think it might be so crude that it is not meaningful.
As crude as it is,
because there's a whole range of issues that are affecting the cost and different areas. I'm just honestly not absolutely convinced that it's kind of insightful or would actually kind of tell us anything meaningful.
The committee might make a judgment about whether it's insightful if we could have the information.
I'm also kind of, keen that we spend most of our time focused on trying to resolve the issues rather than looking backwards.
Well, I don't know whether you were here, Miss Healy, at the previous session, but one of the witnesses gave a fairly disastrous comment.
Yes, manage 90%. Yes.
Yes. Well, there may be other factors involved.
And I think there are other factors involved,
But
which is
even
why
if-
I'm
even-
reluctant. I'm reluctant to point at one particular cause and give a crude number associated with that.
But whatever the figures are, and I think it would be just helpful if we could at least apply some thought to why those starts were so disastrous. I mean, 90% drop in starts last year in London is quite an alarming figure.
And there's
So I
all
think-
sorts of issues.
No, I
related to
understand that. I think perhaps we could have a letter around why you think that figure, that very start figure, is there.
I can certainly, we can write to you with an assessment of why we think there have been challenges to the social housing sector's building profiles.
And when I mean, clearly, as Mr. Betts was indicating, if you take money out of a social housing association for this remediation, important and vital though it is, clearly they're not going to have the money to build new houses. So you were hinting at some change in the funding regime, perhaps allowing them to enter one of the schemes that you've got. Maybe that's a route. When do you think decisions might be made on that?
The ministers have said that they'll set out a social housing remediation strategy later this year.
Brilliant. Thank you very much.
And is that any funding that you might be released for that?
I mean, it's not for me to make that decision.
I'm not asking you if it will be released. I'm saying if it were to be released, would that still be constrained within the 5.1 billion cap?
I mean,
So again, I mean, I think that the choice of what ministers may choose to fund or not fund, I think, is not something that we can give you a view on now.
No.
Two questions around the levy. First of all, it's going to come in after some work, money's been paid out by government through the building safety funds, are going to then offset that. I think the estimate is that at no time will the taxpayer be at risk for more than £6.3 billion. Is that still the figure, even if the programme of remediation is accelerated in the way you hope?
So the taxpayer cap is £5.1 billion. We expect the levy to raise about £3.5 billion over a period of 10 years. Sorry?
Come in after some of that money is spent. Right?
Yes. Yes,
so there
exactly.
will be a time when taxpayers is actually...
So there is so the arrangement is that obviously we've got £5.1 billion allocated. Beyond that, you've got the developer levy. Obviously, developers owe us money for buildings which we previously paid out on to the tune of about £700 million. The levy acts as the balancing factor in that equation. The Treasury essentially underwrite the cash flow gap to the extent that there is one. But overall, obviously, levy rates are a matter which will be published in due course, but also the length of the levy can be varied in order to take account of what the final bill would be in.
Is it right that exposure, the taxpayer gap, will never be more than 6.3 billion?
I'm not quite sure what that 6.3...
I understand it's the figure that the sector could be at risk of or exposed to through NAO assessments.
So the overall range of total cost across the social housing sector developers is 12 to 24 billion pounds. Obviously, we're very keen to narrow that range down. The policy commitment from ministers is that anything that needs spending beyond that 5.1 will be recouped through the levy. Obviously, that depends on the overall amount of demand for the scheme and the number of buildings out there, which is why one of the reasons we're so keen to reduce that uncertainty. But we expect that 5.1 is fixed on as a
That's
matter
the
of
ultimate
policy.
cost, but there will be times when there's more money gone out until the levy comes in.
Yes.
And what's the maximum amount of money that could be owing the 5.1 billion plus money that will eventually come back? What's the total of those two together?
I mean, I can't give you an immediate number off that on the basis that it's calculated on ranges that make a series of assumptions around the pace
Have a
at
note
which.
about that. Okay.
Significant responsibility for this crisis is with non-compliant product manufacturers. So why are they still not on the hook for paying in to solving this problem?
Well, I think my ministerial colleagues have been very clear about their disappointment in the sector coming forward with funding. Under the previous administration, obviously the framework was changed in order to allow easier civil recovery of liabilities from manufacturers and others in the supply chain. Partially because, of course, the relationship between an individual company and an unsafe building is much less direct. So, for example, there will be safe Kingspan products on buildings in individual places, and so therefore it makes sense for the person who originally built that building to get behind what were they marketed, what were they told, how did they understand the responsibility that was provided to them. In terms of broader accountability and financial contribution, again, as I say, ministers are very focused on taking further action, but they'll set out their policy view on that in due course.
And just final question on this. So there's no, there isn't any delay because of any potential. Obviously, we can't speak for the Metropolitan Police investigation in the CPS. Obviously, we know that they will be considering some of these in their charging decision. They'll be considering whether these companies should be charged. That is separate. That is not a factor in delaying the government's approach to securing compensation from the product manufacturers.
The government wishes to support any investigative activity in light.
It's not delaying.
No, a question of financial compensation or financial contribution, either in the form of the levy or of a statutory scheme or of some form of contractual arrangement akin to the developers, is obviously a separate matter which would be looked at on the industry as a whole and is a policy question rather than one of implementation.
But when stomach churning, it's one of the strongest statements I've heard against a private sector organisation in my entire time on this committee, so that was a pretty strong statement. I'm surprised that it's taken all governments, and I'm not making a political point here, so long to pursue the product manufacturers.
Obviously, we can't go into the reasons why ministers have taken the policy decisions that they have in the past with regard to kind of whether levies were placed in one place or another. All we can commit to you is that ministers are looking at a wide range of options here, and we've promised to come forward with further reform to construction product manufacturers.
Another policy issue we've come across today. Okay, well, we've heard that loud and clear. Thank you very much. Yes, yeah.
Peter Morrell did a report into product testing, product safety. The government's never responded. Either government's never responded in detail to that, have they? Is that something that you're going to have a look at in terms of advising ministers about the course of action to follow now with regard to product manufacturers?
It certainly is, and ministers have committed to publish proposals about further reform in the sector soon. I can't give you the exact date for that, but ministers certainly have taken an interest, including in the independent review.
Final question, Ms. Healy, and it's this. We referred at the beginning to these 9,000 to 12,000 buildings in the medium range sector that need remediation of a cost of between 12.6 billion and 22.4 billion, with a medium cost of 16.6 billion. Are you confident at this moment in time that actually the government's contribution of 5.1 billion is going to be enough to do the entire job?
Absolutely no plans whatsoever to spend any more public money than the 5.1 billion in respect of this, and we are clear that funding, if in excess of that, will need to come from other sources, e.g. the Building Safety Levy.
We expect that range to narrow, and we will be able to publish how much that narrows by during the course of this year.
So, extrapolation of your answer, Ms. Healy. If it isn't enough, and you're saying that the government is not going to provide any more, that means that the levy has either got to go up or it's got to be extended.
Yes.
Which is it?
That'd be a decision for
a choice for ministers.
Yeah, well, how you do it is kind of a policy design decision, but fundamentally, kind of, within these ranges, we anticipate that we have projected forward broadly what we expect the levy to be and what we expect public funding to be, but public funding is subject to a cap.
And I think